We'll move to the next session. I hope Mr. Umapathi is there.
Yes, sir. Yes, I've been listening since Barkat Saab's comments.
Umapathi Saab, thank you very much. Our next session is impact of unnecessary arrest on the criminal justice system, which includes police station work, the court work, and increase in the number of under trials in the prison. Umapathi ji, it's a subject which is known to all police officers. So if I will take the liberty of cutting your time by further 5-6 minutes, if you can close in 8 to 10 minutes, I'll be really thankful to you. Now, I must tell you, Mr. Umapathi is a direct recruit DYSP from the State Police Service of 1977, Andhra Pradesh. He worked as IGCID for 5 years. He single-handedly revised the Andhra Pradesh Police Manual in 2017. He was also instrumental in getting the NCB manual revised in 2019. And he has been a faculty at National Police Academy, at Telangana State Police Academy, and now working with ASCII. One good thing which I liked about him was that he said that he filed charge sheets in 238 grave cases and secured 95% conviction, which is a rarity. So with those words, there are many, I'm not mentioning all. I will request Mr. Umapathi to take over.
Sir, thank you, sir. And thanks to all the senior officers who are in this conference. First of all, when you go back to the crime per se, the crimes are considered as a wrong against the society at large. And in addition to its being a wrong against the individual. So wrong against the individual and wrong against the society. That's why we say state versus so-and-so. Then the parameters with which this arrests have to be made are LLED, that is life, liberty, equality, dignity, the principles of human rights. And also the FIRs are registered to set the law into motion. In my service over 36 years in Andhra Pradesh, combined state, where many crimes against women and children I was overseeing about, say, 5 years' time, I noticed that simply because FIR is there, the names are there, the SHO arrests all of them. This was a very, very wrong thing that we have been telling, that saying that you have to get them first, talk to them, even the accused has to be given opportunity. There is what is called audi alteram partem, principle of hearing the other side also. And one of the natural justice principle is the principle of audi alteram partem. So therefore, many people, they're treating FIR as a, say, something like a gospel truth and then put all of them into the charge sheet and then remand them. This was one thing which I was objecting all through, sir. I would just quote one example of a very important, it's a double murder case where the complaint was given with 22 names as accused. Immediately I was in Kadapa, so immediately I verified whether 22 people are involved. So we have to generally check up the background, then find out, then we dropped the 10 names after about 24 hours of investigation, and then only arrested only 12 people. So this is what is called verification about the background of the accused, whether they're present there, whether they're whatever it their other participatory level, whether they're abatement, all the things, you have to do that. The officers have to do. Officers are afraid of dropping the names. For example, if you see the charge sheet, sir, we don't have the national and his NCRB data. In the charge sheet, if you see, there is a column saying that who is not charged. So the column which who are charged among the FIR accused and who are not charged. Who are not charged also were arrested, and then integrated form 3 was issued. But they are not charged, but they underwent, they went to imprisonment, they went to jail, they stayed for 15 days, 20 days, or 30 days. Again, they came back. Imagine, sir, if all these people file cases against the concerned SHOs, imagine the state of affairs in the country. We file, finally, when it comes to charge sheet, you drop away 3-4 names. You file charge sheet against 4, 5, 6 names. But for initial arrest, we make arrest of all the people. So this is one important thing that I would like to point out. Probably NCRB is not picking up that kind of data with is not available in this NCRB data, sir, because I was also director SCRB in addition to crime against women and children. Second important thing is that the complaints, the complainants, for example, I know in important police station like SR Nagar in Hyderabad, Banjagutta. Imagine, sir, 1,500 cases are reported in SR Nagar, one police station level, 1,500 FIRs in a year. Imagine what kind of review the inspector can do and what kind of review the ACP will do or DCP will do is something which, I mean, is left to public imagination. Everybody wants the person to be arrested, and then in addition to that, 41 years CRPH, when it came, a lot of the bar associations were against it. They were saying that you have taken away food from our mouth. Many people said that if there is no such a provision, then they would be sent to court. In the court, they will file a bail application, and they'll get, for filing bail application, they'll get some 10,000, 20,000, depending on the case. Now, they're all worried about the 41A. In fact, Hyderabad, a lot of bar association people, both Nampally court and also the city civil court, they say that these are the provisions which have really made them go hungry. But the point is that during training itself, if you tell the, you know, sir, you were also director and I was also joint director. 41 years after it came after the Malimat Committee report, I suppose, Justice Malimat Committee report, and post that these reformations have taken place, and then all these 41, 41A, B, D, and 51A, all these sections have come. And these sections have cast certain responsibilities. Because of that, certain restrictions are there by the SHO, for the SHO. But many inspectors or sub-inspectors still think that they can just make arrests without any paying heed to these things. Recently, High Court has chastised one ACP, one inspector of police, and one SAF police for making a wrong arrest. In fact, they almost went to punish them. So with the result, what we are seeing is the station level, we have 739 districts in our country. Suppose every SSP is, every day he conducts a DSR, daily situation report. Every day they conduct a cell phone conference. Can it not be one of the important aspects of in the cell phone conference in a day, and saying that, and weekly arrest review can be done in the weekly review, whether they have made the arrest unnecessarily or necessarily, whether was there a necessity or not. This should be one of the important aspects for all the SSPs and deputy commissioners or commissioners in the review, because this is what we are now talking about. Vis-a-vis the victimology part of it. The victims always say, sir, the police station people have taken money. They have not arrested the accused. In fact, every day I get about 20 to 30 calls in Hyderabad city, because I worked for a long time, 6.5 years as a deputy commissioner. Every day many people ring up. I said that there is no provision to arrest them. There's a new provision has come, 41A. They will only give a notice, and after that they will send them. And this kind of understanding is not there in the public. Public is still not aware. Public still feel that the police station, the minute complaint is given, it's a cognizable case where police can arrest. Only they talk about 41.1, but they're not talking about 41A, which is a provision that is forgotten about them. And in fact, the police also fail to make them understand, or maybe some educated people may be asked to read the provisions. But if you see, sir, more of education, more of activity like Kerala, for example, Kerala has got highest educational percentage of people who are very educated. In Kerala, the number of arrests made are also pretty high. So people, those people who are also thinking that the power to arrest, Kerala people think that maybe the victims may be feeling that the police is not arresting like that. If you see, if you take the examples of UP and Bihar, UP, their violent crimes are 51,000 and number of arrests made are 3,87,000 with a population of 23 crores. If Bihar, if you take, sir, it has got 12.85 crore population, same 51,000 violent crimes. UP also 23 crore population, 51,000 violent crimes. Bihar also 51,000 violent crimes. And their number of arrests made are 1,76,000. If you take Kerala, Kerala has got only 3.46 crore population, but the number of arrests made are 2,11,000 and violent crimes of 10,000. So somewhere we feel that that awareness and education, does it reduce the number of arrests to be made by the concerned state police organizations? Is still to be researched and studied. Second important aspect is that the SSO should be told that this is a new dimension of the law. Earlier law, when they were recruited perhaps in 1900 and in 2000 and all. 2009 onwards, these are the human rights aspects have come in more into picture because there are wrongful arrests are made by the many people in the country. In fact, some of the inspectors ask them to go and file, if it's not a regular case, is not made out, and 156.3, and 156.3, they register FIR, then they go out of the way to take action against the people. More particularly, this is happening in the cheating cases, all these cases, what's happening around. So
Umapathi Garu,
sir,
2 minutes more, please close it.
yes, sir. So, for example, that the police station also, if I see, sir, if you take, they have got 10 to 12 hours of time is taken for every documentation of every arrest. And if you take the, if you take it in the impact in the court also spends about 8 to 10 hours, and police spends about 8 to 10 hours. And taking him to, first of all, to the magistrate under section 54, they have to be examined by the magistrate, sorry, by the medical doctor. And doctor takes another, say, 1 hour time to examine and saying that there are no injuries. Then when they send to court, sometimes they send him to the residence of the judicial officer. And from the residence, they take him to again back to the police station or back to the headquarters police station. Again, a regular court will open at 10:30, then wait till about the evening that remand report or some bail report is filed. So these things are taking a lot of court's time also. Prisons, for example, if they're sent to prison, the kind of for offenses which do not need not necessarily go to prison. Well, there is a NCRB data has got about the heinous offenses, non-heinous offenses. We are taking about heinous offenses only. If non-heinous offense also, if they're sent to jail, the kind of trauma they'll undergo is terrible, and the kind of already there is a lot of pressure on the prisons. Though the population of the prisons in our country is much lesser. In fact, for only 478,000. Whereas if you say US, for 33 crore population, they have 20 lakh people in the jail at any given time. Ours is a real, really maybe evolving democracy. In evolving democracy, we're also more concerned about the rights of the individuals. And therefore, I feel that the court's time can also be saved to conduct trials and then to make many other things in the court processes, like NBWs, executing NBWs, issuing NBWs. For example, and police also, if they reduce this kind of arrest, they can more focus on the NBWs. In fact, NBWs wise, you have at any given time about 80,000 NBWs are pending in our country. 80,000 NBWs. So 80,000 NBWs are a big number. 80,000, 8,06,000. Sorry, 8,06,000 NBWs are pending. Out of 41 lakh NBWs issued, 8 lakhs are pending. So we could as well spend the time in executing the NBWs against the already accused who are maybe in heinous offenses, maybe in other places. And that could be rightfully, that time can be used by the police station. Lastly, about the prison also, there are 2 counselors outsourced. So therefore, how do you then transform them also to see that the further the recidivism, to reduce recidivism to people who are committing again over and over again. So we have somehow flawed the system of even reformation also. We say prisons and correctional services, the wording is there. But where is the correctional service happening? I'm really worried about. At least 2-3 jail warders posts can be converted if the state governments don't have the wherewithal, can be made into counselors. So that they will at least reform 10 to 15% of people, and that will be a big gain to the society. So with this, I thank you, sir, and thank all the senior officers for giving me the opportunity to speak to you, sir. And thanks once again for this workshop, sir. It has really enlightened us. And thank you so much, sir. Sir, I'm done, sir. You have given me 8 minutes time. I think I finished.
Thank you, Umapathi Garu. Actually, you took 13-14 minutes, but it's perfectly fine. He made 2-3 very important points. One is FIR is not a gospel truth. So FIR is the initial complaint, and police officers need not resort to all the arrests based on the FIR alone. And the second important point he made is that the SSPs during a weekly reviews or a daily review number of arrests made and whether they are necessary or not should be reviewed on a regular basis. That's a very good suggestion. He also mentioned about Indian prison population at 4.78 lakhs, and which is much less compared to USA. Just a small correction here. It's a per day population, but actually if you take in a year, it is around 18 lakh people who go through the prison system in India as well. So thank you very much, Mr. Umapathi.